Hi, I'm Carl Pearson, and this I've entitled Bankruptcy for Mortgagor-Homeowners Has Benefits and Pitfalls. And it's complicated in some respects, which is why I want to do this video. I'm a foreclosure defense attorney, but I'm not a bankruptcy lawyer. And I want to give homeowners who are threatened with foreclosure some of my thoughts about filing for bankruptcy. I have done this for several companies and individuals, so I do have experience with bankruptcies. But as I said, I'm not a bankruptcy lawyer, and that's so for many reasons, including the complexity of bankruptcy laws and rules and options, and the drain on my time to be in court all too frequently and to try to do all the things required to have a bankrupt remain in bankruptcy. Here is a point I want you to remember first of all. The defenses that are used in the defense of a foreclosure action are to a very great extent the claims to be considered when drafting a quiet title action for the state court. It's a question really of who sues first. With that said, there are some basics that homeowners threatened with foreclosure should consider. 1. Bankruptcy, as I see it, is a last resort or final option among a variety of options to save one's home from foreclosure, auction sale, and then eviction. Remember the saying, quote, always keep your options open, unquote. In other words, don't use an option unless you are forced to do so. 2. In states where foreclosures are done by a foreclosure action called judicial foreclosure states, I usually recommend that the homeowner wait for the lender or servicer to sue first, which is a variant on keeping one's options open. 3. In states where foreclosures are without a court action, and those are called the judicial non-foreclosure states, the non-judicial states, I generally recommend that the homeowner sue as early as possible to get discovery that will be needed to obtain the desired injunction. 4. Bankruptcy is exceedingly easy to create simply by e-filing, which a bankruptcy-oriented law firm can do within hours, and by such filing and appropriate notice to the seller and auctioneer will automatically stop or stay a scheduled foreclosure auction sale. 5. But remaining in bankruptcy for a long period and avoiding a motion by the lender to vacate the automatic stay can be costly and involve fancy legal work beyond the capability and interest of the bankruptcy filing lawyer to do or for you to afford. 6. You are not allowed to pay your lawyer after he or she files the bankruptcy petition because you're under supervision of the court without a court order, which the courts aren't interested in granting until months have passed or the case has ended. 7. The way to get around this restriction is to have someone else make the payment, as long as this is not being paid by you surreptitiously. 8. You could lawfully pay your bankruptcy lawyer, say $20,000 in advance of your filing. Of course, if you had $20,000, you wouldn't be behind in your mortgage payments and need bankruptcy. 9. In many, but not all of the nation's bankruptcy courts, the homeowner has to file what is essentially a quiet title action called an adversary proceeding as a lawsuit within the bankruptcy proceeding, and do so within 90 days of the bankruptcy filing to be able to challenge the validity of the mortgagee's claimed mortgage lien. Merely checking off the form option that you dispute the amount of the lien is not sufficient. 10. Because you do not pay your bankruptcy lawyer $20,000 in advance, and because he or she can't get paid usually until the bankruptcy is over, the bankruptcy lawyer does not file the required adversary proceeding, and you unknowingly lose your right to contest the validity of the mortgage. I don't know if you can get around this problem, and the problem should be considered when deciding whether to file for bankruptcy and to keep your options open if you can. Your defense in a foreclosure action is the equivalent of the needed adversary proceeding, and far easier to obtain and afford with no restrictions upon paying your attorney. So really what I'm saying is that keep in the state court as long as you can before having to switch and go into bankruptcy, which is a federal court. 11. There are at least 3 major benefits to bankruptcy. The first is the automatic stay of all litigation and the auction sale of your home. The other 2 benefits are homestead rights and equitable jurisdiction. Homestead right can be very important down to of little importance, depending on state law. If state law is too low, you can take the federal law instead. If you live in Florida and in the mortgaged property, you are able to keep your home from your creditors no matter how valuable it is. Georgia, on the other hand, allows a homestead exemption up to $10,000 worth of the home under certain circumstances. California is at least $75,000 worth of the property, and New York is based on the county location and ranges from $75,000 to $150,000. 13. The homestead exemption in Florida, to which Trump recently moved, allows a primary residence of unlimited value to be protected from creditors as long as the debtor has lived in Florida for 40 months or more, and the property is not larger than half an acre or in a municipality or 160 acres elsewhere. In other words, if your Florida home is worth $50 million, it is exempt from creditors. 14. There is for new bankruptcy filings a federal homestead exemption of $22,150, which option would be selected in bankruptcies in Georgia and other states with exemptions lower than the $25,150. 15. The third benefit is usually the best and needs to be explained. When a foreclosure action is commenced by a lender or servicer in a state court, or a quiet title action is commenced by a homeowner in a state court, the state court judge has no equitable power to order the lender or servicer to give the homeowner a loan modification to save the home from foreclosure. Instead, the state judge and even a federal district court judge, under long existing federal case law requiring application of the same state substantive law under Erie v. Tompkins, must either enforce the mortgage and order foreclosure or give the property to the homeowner free and clear of the mortgage lien. State judges almost always hold for the lender or servicer, except where the homeowner can prove the defense of the statute of limitations. That really is essentially the main defense that could allow the homeowner to keep the property free and clear of the mortgage in state court. 16. On the other hand, bankruptcy judges have equitable power to adjust the terms of mortgages and notes and order loan modifications, so that if a lender fails to offer an affordable loan modification voluntarily during a foreclosure action, or even in a quiet title action, the homeowner, by filing for bankruptcy before any auction sale takes place, can have a shot at getting a bankruptcy judge to exercise that equitable power and grant an affordable modification thereby saving the home for the homeowner. Well, it's complicated, but I've said what I wanted to say, and I'll be back soon with my next video.